I have been given 50 seconds to ask each of you questions and to hear your answers, which of course is patently absurd. So I'd ask if you would just answer my question directly. This isn't a question, Judge Gray, I may vote for you anyway, but I'll commit right now in front of God and country to vote for you if you'll move back to Louisiana. Judge Lynn, I've read a number of your writings. I want to, you wrote an article in December of 1998 entitled Person of Faith, Race and Religion as Experiential Knowledge. You wrote it in a journal called Perspective. And this is what you said, I quote, your words, not mine. The problem with the Christian coalition is not that they are Bible thumpers, parentheses, there are personal beliefs that often result from religious experiences, close parentheses, but that they are bigots, end of quote. Did I quote that correctly?
I believe you did.
Did you write that?
I did write that when I was 18 years old, or 20 years old, excuse me. I do want to be clear. I do not agree with that today. I wrote that before I went to law school, before I had any kind of
You were a grown woman when you wrote this.
I'm sorry.
What's up, patriots? Welcome back to Liberty Trigger. Today, we're breaking down a judicial confirmation hearing that tells you everything you need to know about what's happening to our courts and why we have to stay alert if we care about the Constitution. First, the senator reads back a line from an article written by Judge Lynn when she was at Harvard. And listen to this. She wrote, "The problem with the Christian coalition is not that they are Bible thumpers, but that they are bigots." A 20-year-old Harvard student publishing an article calling Christian conservatives bigots, not in a private diary, published in an academic journal. That tells you the mindset, hostility toward Christians, toward religious Americans, toward the backbone of this country. Let's dive right in.
You were a grown woman when you wrote this.
I was 20 years old when I wrote it. It was before I had a professional career.
You were in your third year at Harvard?
I was
a senior at Harvard.
I was a junior at Harvard.
Junior. So you were 3/4 of the way through your Harvard education, and you wrote that.
That is correct, Senator. It is 20 years before I became a judge. I do not agree with it today. I do want to be clear about that.
Okay. Judge Simmons, let me just ask you a couple of questions. You finished law school in 2004?
Yes, sir.
All right. Have you ever tried a case in federal court?
I have not seen there.
Have you ever filed a brief in federal court?
I have not practiced in federal court. My entire practice has been in the state court.
Okay. Have you ever argued a motion in federal court?
I have my entire practice of over 12 years as a prosecutor has been in state court, Senator.
Okay. Have you ever, you serve as a state court judge, have you ever presided over a jury trial as a state court judge?
In the 5 years that I've been on the Superior Court bench, I have been in a moving department, and now I'm the supervising judge.
Have you ever tried a jury trial?
As an attorney, I have tried.
No, as a judge.
As a judge, I have presided over court trials, not jury trials, sir.
No, so the answer is no.
I have not presided over jury trials as a judge.
Have you, in the 5 years you've been on the state bench, have you ever written any opinions, issued any opinions?
Well, sir, I've been in moving departments in the 5 years that I've been as a Superior Court judge. We don't issue written opinions in moving departments on the Superior Court.
So the answer is no?
In the 5 years I've been on the Superior Court, I've been in moving departments. We don't issue written opinions in moving departments.
Okay. What is the standard of review in federal court for questions of fact?
For questions of fact by the trial court, it is clear error, sir.
Okay. What's the standard of review for questions of law?
In the trial court level, it's de novo.
Okay. What's the holding in Map v. Ohio?
Map v. Ohio, since I've been practicing as a district attorney for the last 12 years, as well as a Superior Court judge over the last 5 years, I know what the holding is. It escapes me as I currently sit here, but
Okay.
as a
What's the Chevron doctrine? You'll see that a lot.
yes, Chevron deference refers to an administrative agency that's interpreting its own rule. It created a two-part step test. The first step in that test is whether Congress was clear.
You know it. I got you. What's the political question doctrine?
I have not, as a Superior Court judge, and over the last 5 years, and as a deputy district attorney for 12 years, I have not practiced in a federal court. So if I am so fortunate enough to be confirmed, I will obviously apply the applicable law.
Okay, I want to talk about the United States Constitution. Is it a doctrine of plenary powers or enumerated powers?
Enumerated powers, sir.
Okay. I yield back 1 second, Madam Chair.
Now she sits there saying, I don't agree with that today. Well, I'm sorry, but when you're a grown adult, 3 years into Harvard, preparing for a career in power, you don't casually throw around accusations like that unless that's how you see people. This is the exact attitude the left has spent decades cultivating in elite institutions. Christians are the enemy. Conservatives are backwards. Faith is bigotry. And now these same people want lifetime appointments. Then we get to Judge Simmons. And folks, this part is stunning. This nominee, poised for a federal judgeship, has literally never tried a case in federal court, never filed a federal brief, never argued a federal motion, never presided over a single jury trial, never issued a written judicial opinion. Not one, not ever. Imagine applying to be a pilot without flying a plane, a surgeon without performing surgery, a mechanic without touching a wrench. But in today's left-wing judicial pipeline, experience is optional as long as you check the ideological boxes. When asked about Mapp versus Ohio, one of the most fundamental Fourth Amendment cases, she froze. It escapes me. Then the political question doctrine? Blank. These aren't obscure trivia questions. This is 101 level constitutional law. If you don't know the basics, how are you supposed to defend people's constitutional rights? How do you overturn government abuse when you can't name the case that set the standard? This is why elections matter. This is why judges matter. The left doesn't want constitutional judges. They want ideological activists in robes. They want people who will defer to government agencies, push social agendas, and see the Constitution as optional, flexible, living, evolving. But patriots, if the Constitution can mean anything, then it means nothing. This hearing is a wake-up call. It's not just about one nominee. It's about an entire system pushing people into power who don't respect the Constitution, don't respect traditional values, and in some cases, don't even respect Christians. We cannot afford to ignore this. We cannot sit quietly. And we absolutely cannot let ideology replace competence on the federal bench. If you believe judges should actually know the law before interpreting it, hit like. If you believe faith and freedom are worth defending, hit subscribe. And share this video with someone who needs to hear the truth. Stay loud. Stay proud. Stay American. God bless you, and God bless the United States of America.